Okay, good afternoon, everybody. Thank you very much for joining us. 12 o'clock, Wednesday, the 24th of August. My name is Alan Cowie. I'm from the New Anglia Growth Hub. Apologies if you can hear the whirring from the fans behind us, but as I'm sure you're all trying to stay cool on this warm summer's afternoon. So New Anglia Growth Hub, free support for growing businesses. We cover Norfolk and Suffolk. We've got people joining us from across the country today, but if you'd like to find your local Growth Hub, because we are part of a network of 38, then just search Growth Hub Network. Before I introduce today's guest from the Intellectual Property Office, I would like to say thank you very much to Barclays, who are supporting this series of webinars that we've been running on different subjects each month, from grants to business planning, lending. And the aim really just to give you about half an hour of presentation with some useful information that hopefully you can apply to your business. If you want to watch any of those presentations, they're available on our website at newangliagrowthhub.co.uk. Would like to keep this. Would like to keep the flow going, so we'll take questions at the end if that's okay. But I've already had a few questions coming in on the chat box. That's absolutely fine. We'll get to those as soon as we can. If you do want to ask your question live, though, then you should see a button. Looks like a little hand. That's the raise your hand button. If you press that, we can come to you and you can ask your question. But as I said, in the meantime, feel free to get questions in early on the chat box. I won't carry on any further, and I'm going to introduce today's guest, who is Gary Townley from the Intellectual Property Office, and Gary's joining us live from Newport in South Wales. How's it going down there, Gary?
Oh, it's all very good. Probably as nearly as warm as you, but not quite, I would think, here.
The floor is yours, Gary.
Okay, thanks, Alan. Right, we seem to have stalled just a moment. Bear with me. There we go. So, right, as Alan said, my name is Gary Townley. I work for the Intellectual Property Office. Some of you may be unfamiliar with the name, but we previously were called the Patent Office, which we were for about 150 years, till about 6 years ago we decided to rebrand from the Patent Office to the Intellectual Property Office. The reason being is, going out of the Patent Office, people were confused as to what we actually covered. People would ask us, well, where do I get a trademark? Where do I get copyright? Well, we cover all those rights, so we don't just cover patents. So obviously, to reflect that, we rebranded, as I say, about 6 years ago, just to reflect that we cover all areas of intellectual property, and that's what we're going to be talking about in the next sort of 20 minutes or so. I work for the business outreach team, and my role is actually raising awareness. So I'm not actually selling you anything as such. I'm just trying to make you more aware of what IP is, and how relevant it is to your businesses, because IP will affect every business. Okay, so first of all, who we are. A lot of people are confused and they think that we are in fact a commercial organisation. We're not. We're actually part of government. So we're now part of the newly formed department at BEIS, Business, Energy and Industrial Strategy. As Alan just said, we're primarily based in Newport down in South Wales, although we do retain a small London office, so if you want to see us in London, you can do so. But primarily, we have around 1,000 staff who are based around me here in the office, and they're sort of beavering away, examining trademarks, examining patents, etc., as I'm speaking to you today. And as it says there on the screen, our task is to stimulate businesses to use IP. The reason why we think we need to stimulate this is that it's optional. Okay, so there's no legal requirement for you to use our services. So when it comes to setting up a business, using business tools, services, etc., we tend to come right down the list simply because it's an option. It's not like doing your tax return or your company's return. IP is an option for you, but what you'll find out in the next 20 minutes is that it will add value to what you're doing. So as I said, why we think it's important, as you can see on the slide there, the graph, and this is a growing trend. IP in many businesses these days is actually becoming worth more than the fixed assets. You can put that in terms of a story that I heard someone say the other day. If you think of someone like Uber taxis. Uber taxis, no doubt you've heard of them. They are the largest taxi firm in the world today. How many taxis do they actually own? They own actually 0 taxis. They own no taxis whatsoever. What they own is the IP to enable you to actually book a taxi, valued at billions of dollars, and the value in that company is IP, not the actual fixed assets. So again, apply that to your business. What do we actually own when it comes to our fixed assets? Yes, we own some tables, some chairs, but what actually IP do we own in our business? And you might find, surprisingly, that the IP amounts for quite a considerable sum of your business value. So what is intellectual property? Again, everybody's heard the terminology of intellectual property, but the skill is identifying which area of intellectual property you own and whether or not you wish to protect it by filing for one of the rights. So as you can see on the screen now, these are the areas we cover. So first and foremost, obviously patents. We opened our doors in 1852 to protect inventions. In central London, obviously, that's where you came to protect all your new ideas. And as time's grown, more and more things have been added to what we do. So yes, indeed, we are the Trademarks Registry. Now, every business will own a trademark. Whether you've registered or not, you have chosen a name under which you are going to trade or are trading already. That potentially is your trademark, and I'll cover that in a bit more detail in a short while. Designs protect the appearance of a product. So if you are selling products that people buy because of the appearance, the look, and you would think that everything these days, will have a slight design element to it. Maybe it's not the functionality, maybe it's not the price you're interested in, but it looks great, in which case you can protect the look of that product with a registered design. Copyright. Now, every business uses copyright, either as an individual or as a business, you will be using copyright. That is for artistic and creative works, things like films, websites, photographs, promotional literature, software, all that is covered by copyright. And again, I'll give you a little 5-minute spiel on what that protects. Other things which fall under the umbrella of intellectual property, trade secrets. Yeah, so if you've got something you can keep secret for a length of period, it might be the way forward for you. Confidentiality agreements, no matter what business, what area you're in, please use confidentiality agreements. You do not want your secrets leaking out. Put one of those in place. It's a contract between you and the other person who signs that particular contract. It keeps things secret for your business. Database rights, so yeah, if you've got a list, even just a list of customers, that potentially is covered by database rights. And last but not least, there's also plant varieties. So if you are coming up with new types of plant, seed, vegetable, then you can still protect that using intellectual property. So what we'll do, we'll look at them individually, and the first one we'll look at is that of a trademark. And we're going to look at trademarks first because, as I've already said, if you are in business or starting a business, you potentially will own a trademark because you have chosen a name to trade under. So what's a trademark? A trademark is any sign that distinguishes your goods or services from that of another company. To give you an example there, if you're in the market for a new pair of training shoes, you will wander into your high street leisurewear shop, and on one wall you'll see loads of training shoes with 3 stripes. They look very nice. On the opposite wall there'd be loads of training shoes with swooshes on them, and they look nice as well. But I know as a consumer, the ones with the 3 stripes are Adidas and the ones with the swooshes are Nike. Those 2 signs tell those companies apart, even though they're making the same type of product. That is what a trademark tries to do, distinguish you from a competitor, even if you're in the same industry. What a trademark costs, if you're going to file for a trademark and you do it yourself, if you do it online with us, a trademark in the UK will cost you £170. That's one trademark in one area of business. The system is divided into 45 different classifications or classes. You tell us which class you operate in, you file one trademark, that will cost you £170. For any additional classes you wish to file for at the same time, that will cost you an additional £50, okay? And it lasts for 10 years, so it's not £170 per year. That fee will cover you for 10 years protection. Effectively, it can last forever because in 10 years' time, we will remind you. Do you wish to renew your trademark? Yes, please. You pay the money again. It goes on for another 10 years. Trademark number 1, which is a red triangle for beer, Bass Brewers, registered in 1876, still in force today because they just renew it every 10 years. What a trademark shouldn't do, and a lot of people actually fall into this trap, is describe your goods or services. So if it's descriptive, then basically we're not going to allow it as a trademark. To give you an example there, I was driving into London yesterday to do an event. The van in front of me, on the back of it, had Camden Garden Centre. Now from their logo on the back of the van, can you tell me where they're based and what they do? From my mind, I was thinking they're based in Camden and they're a garden centre. That basically is not their trademark because that's where they're based and that's what they're doing. So the more descriptive you are, the less likely you are to get it as a trademark. Common questions we get asked as we go out and about doing talks and seminars, etc. You cannot register a dictionary word. Dictionary words should be free for everybody to use. No, you can register dictionary words. Is Apple a registered trademark? Of course it is, but it doesn't relate to the industry they're in. So Apple for a greengrocer, we would not allow because it's a descriptive term for what they're selling. Apple for computers or music is absolutely fantastic. Changing the spelling, we often get this one, I'm going to change the spelling using a Z or a C. No, you can't. If you're going to open a supermarket and call yourself A-Z-D-E-R, unfortunately that is too close to ASDA, so don't do it. You don't have to use a registered trademark. You do. You can't just file and not use a trademark. You know, people say that large businesses will just file everything. You can't. You have to have an intention to use a trademark within 5 years of registration. And the last one, which we get commonly, probably every time we go out, I am registered at Company's House, therefore I own the name. You do own the name, but you only own it on the Company's House register. You do not own the trademark. They are separate registers. Potentially you want both, so therefore you go to Company's House and you also come to the Trademarks Registry to register it as your trademark. So all those, unfortunately, are false. What can you register as a trademark? Well, your business name, a logo, your domain name, a slogan such as I'm loving it, just do it, a colour theme. So if I were to say to you yellow for breakdown services, probably you're thinking of the AA because they own the colour yellow for breakdown services. A shape. What about a tubular, triangular bar of chocolate? Probably you're thinking of Toblerone, and you should be because they own the shape of the chocolate and the shape of the box. Non-traditional marks, things like human gesture. ASDA own the rights to somebody patting their back pocket twice. Music, used every day in advertising. If you hear a jingle, a sound, yes, indeed, you can register music as trademarks. And smells, indeed, olfactory marks can also be registered, but it is very, very difficult to do, so please get advice if you're going that route. But certainly your name, certainly your logo, they should be registered, or just make sure you're not infringing somebody else. That's trademarks. The second area we cover, let's say this is a whistle-stop tour, is the wonderful world of a registered design. This protects appearance. So anything from bicycles, vehicles, lighting, crockery, jewellery, cutlery, furniture, perfume bottles, patterns, anything that people buy because of the appearance of the good potentially can be registered to stop others copying the look of your products. What is a registered design? Well, it protects the outward appearance of a particular product. It can consist of shape, contour, pattern, ornamentation. £60 gets you a design in the UK, okay? That's for your first design. Any subsequent ones you file at the same time will cost you an extra £40. Now that initially will last you for 5 years. Again, it's not an annual thing. £60 for 5 years protection for the look of your product. It doesn't protect the function of the product or how it works, okay? That's when we're looking at patents, and we'll come on to that in just a couple of moments of time. Now, even if you don't register your designs, you still may have a fallback position of an unregistered design. Unregistered designs in the UK can last potentially for up to 15 years. In Europe, they will last for 3 years. So even if you haven't registered and somebody starts copying the look of your products, come to us, get some advice, because you may be able to take an action under an unregistered right. But obviously having a registered design is a much stronger, gives you a much stronger position. Common questions with designs when we go out and about. If I make 6 changes, 7 changes, it becomes a new design. Sadly, no. You've got to design further away from what has been designed before. Just by making several changes, it does not make it a new design. I can't sell before I register my design. You can. In the UK, you have a 12-month window of opportunity. You can put your products on the marketplace and still come back within 12 months and register those designs. My UK design protects me in Europe? No, sadly it doesn't. There are European routes, and again, for filing in Europe, it costs €350, but that covers all 28 countries. Again, advice on that, get on our website and we will show you how to do that. And last but not least is the one, again, we commonly get, if I haven't registered, I have no protection. Potentially you have. You have an unregistered design right. Again, if someone's copying your designs, come to us, get some advice, have a look at our website, and that might put you in a better position to take an action. So that's trademarks for your brand, designs for your appearance of the products. The third area we're going to look at is that of a patent. Now what a patent protects is the functionality of the product, how the product actually works, or indeed how it's made. So what's a patent? A patent is an agreement between the state and the inventor. We will give you a limited monopoly in respect of your invention, and that will last for 20 years. After 20 years it expires and anybody can actually use that invention. So exclusive rights, a monopoly if you like, for 20 years over your invention. In return for that monopoly, we want something from you. First of all, we want a description. So we don't want a working model, okay? Most people assume you've got to have a prototype, you've got to have a working model to actually file for a patent. You do not. We expect you to describe in writing what your product does and how it does it. We also want some fees. So some fees in respect of a patent, from application to actually getting your patent granted, we will charge you £230, and that's staged over about 3 years. So again, relatively low costs. However, drafting that description is complex. The way you word the application is what you get your protection for. In the world of a patent attorney, there is no such thing as a wheel. A patent attorney will refer to a wheel as a ground engaging rotational member. That means I can't get round that. I can't put a disc in there, a circle, a bearing, because it's anything that hits the ground and rotates. So therefore the wording is crucial, which is why we would advise you to use a patent attorney when you're coming to patents. A patent attorney will typically charge you between £3,000 and £5,000 for filing your application, and that's for the UK only. So please, if you're going down the patents route, please make sure you have a business plan and put that in place before you actually file your application, because that's really important when it comes to fees and costs when it comes to patents. Common questions we get asked when we're out and about with patents. As I said, I need a working model to file. You don't. Actually, it's all done in writing. So make sure that the description will cover adequately what you're trying to protect. The second idea is that people assume that I can show people my idea before I file my patent. No. The most crucial thing when it comes to patents is that it's brand new when you file it through our door. If you've sold one, if you talk to someone about it, if you display it, then basically you're not going to get a patent for it, because basically it's no longer new. Even though it's you that's shown it, it still is regarded as a prior disclosure, therefore no patent can be granted on that particular idea. People often assume that patents are secret. You know, I'm not going to see anything for 20 years. Patents are not secret. At 18 months, we publish everything that comes into the office. If it meets our criteria, we publish it. You can see exactly what Sony are up to, or James Dyson, by searching on our website. The system's called a SPASnet. Log in there and you can search on technical terms such as plastic and bicycle. You can search for inventors, you can search for company names. So basically patents are not secret. Anybody can view them after 18 months. The other thing people assume is that having a patent will guarantee success. They won't. We receive something in the region of 23,000 applications a year. Of those which are granted, probably around 8,000. Of those which are commercial success, it's anyone's guess. But there's no guarantee by having a patent you will be a commercial success. So you've got to do a lot of homework. A patent is really just the starting point. So all those, unfortunately, false. The last area, just for 5 minutes, the one we're going to cover is the area of copyright. Now, unlike the other rights, copyright is free, it's automatic. Now, copyright covers things artistic and creative. So anything from books and films and that type of thing, I'll show you in a minute. So although it's free, although it's automatic, you do have to qualify. And the first qualification is that it has to be recorded in a material form. If it's an idea in your head, there's no protection. But as soon as you turn that into a book or a film or software or music, then it's protected. So first thing, it's got to be recorded in a material format. It's got to be original. Obviously, you cannot have copied it. As the word said, it's a right against copying, and it's got to be published or shown or displayed here to qualify for UK copyright. But pretty easy to qualify, and it's free and it's automatic. No fees, no forms, no register. Common questions we get out and about when we're asked about copyright. If it hasn't got the C in a circle by it, the year of creation and the owner, it's not covered by copyright. It's free, it's automatic, you don't have to put anything next to material. Copyright will subsist in that material as soon as it's created. I can copy 7%, 10%, 15% without it being an infringement. No. With copyright, it's about quality rather than quantity. If you copy 1% of my material and I can tell it's my material, potentially that's an infringement. If I acknowledge where I got it from, I can use it. So there was a lovely picture on the Daily Mail website this morning. I'm going to cut and paste that, put it on my website and say courtesy of the Daily Mail. You can't just take and lift and use. You have to get permissions to use. And the last one, which you get all the time, I've paid for it, therefore I own it. Unfortunately, in copyright, it doesn't work like that. Unless copyright is assigned, copyright is transferred, the owner will be the first creator of the material, subject to the contract and subject to being employed to do it. So be clear, just because you paid for it, you won't necessarily own the copyright in that material. What copyright protects, as I said, it's anything that businesses use, from books, manuals, training manuals, promotional literature, computer software, websites. So all those things businesses will be using, and it's protected automatically with copyright. Who owns it? As I said, usually it's the first creator of the author, unless you're employed to do it. By employment will mean you pay their national insurance. If you don't pay their national insurance, they are a contractor and they will retain ownership of anything they create unless it's in the contract. So make sure it is in the contract. There is our website. You can see it on our page there. Loads and loads of free information which you can go down in there and use, covering all those areas we've just touched on this morning: trademarks, patents, copyright designs, lots of free tools. If you click on the orange suitcases you can see there, that takes you into business tools that you can use to your heart's content, free of charge. We have obviously an information centre that you can call up, 0300 300 2000. Your call is important to us, but you might have to listen to a 40-minute piano solo. I am joking there. We will answer the calls within about 5 rings. So if you have any queries, you can phone us up and we will answer those for you. So that's sort of coming to the end of the formal presentation. These are the tools that are freely available online. IP Equip, which takes you 10 minutes to do and you'll get a certificate. The app you can download to your phone. The health check, diagnose what your company owns. IP Basics, a series of videos and books that guide you through the world of intellectual property. And if this has whetted your appetite, you can do a masterclass, which we do charge for. Unfortunately, we do charge at £200. You do it online or in person with us. So that's the end of the presentation. Thank you very much for listening. I believe now there's probably a time, 5 minutes, for questions to come in. So I'll probably hand you back to Alan,
yeah,
and he will sort of run through the ones he wants me to answer, I believe. So thanks, Alan.
Thank you, Gary. Very interesting stuff. And we will go straight to questions, I think, because we've got a few that have come in here already. This is from Samira. She's a digital editor working in the healthcare sector, saying that she reports from conferences, from launch of new products, seminars, and so on. So it involves taking audio recordings, taking photographs, doing interviews, and so on. So does she need permission from the organizer of the event? Do they need to get consent to the speakers if you're taking photographs of them giving presentations and that sort of stuff?
Okay, well, we'll take a step back. First of all, she's doing this. Is she employed to do it? I.e., is she employed by an organisation to do it? In which case, she won't own what she's creating. It'll be owned by the company, because that's how it works, because she's employed to do it. Secondly, then, if you are going to any seminars, it is best to seek permission, because if there may be terms and conditions which you may need to apply to if you're entering the premises or the actual presentation itself. So it's best to check it out with the organizer to see what the rules and regulations are. Some will want you to sign up and make sure that everything you do is checked by them before it goes out. Others will probably allow you to do it without any notification or whatever. So check it out, because there will be terms and conditions that the organizer will need you to meet, basically.
Okay, hope that answers your question, Samira. Khalifa, are you on the line? Can you hear us okay? Okay, no, well, let's go to Julie. You've just put your hand up. Julie, can you hear us? Hello, Julie?
Hi.
Yeah, hi.
Hi.
Do you want to ask your question?
Yeah, I just had a question with regard to, well, I had a quick look on the website. I wasn't sure, I wanted to register a name for a new networking organisation. and I wanted to also register the logo, which I haven't actually developed as yet. I couldn't see on the website how you would do that simultaneously.
Okay, yeah, you can file both, so you can either file for just the name alone, or you can file for the name and the logo, or you can file for a combination of both. Now, as you go through the process, obviously it's an online form, you fill in your name and address details. Next session thing, it will ask you to upload what you want to register. Now that can be just the word only, or it can be the logo, and as you file that, that'll be uploaded, and that's the thing that we will examine for you. So you won't see it until you start the application process. Okay, so it'll just ask you to upload an MP3 or a JPEG or whatever you're actually trying to register.
And to find the trademark section at the top of the page on the website, the gov.uk/IPO, there's a list of the areas. If you click on trademark, there should be another list under there, and you can click for apply for a trademark through that. So that's how you get to this initial.
Yeah, but you won't actually upload until you actually go through the process.
Okay, lovely. Thank you very much.
Okay, thank you, Julie. Just going back to trademarks, Alex McKenzie, the question here. It's something, if it's something around fitness and it has either words fitness or gym in the name, can you use it? I mean, using your Camden Garden Centre example, obviously that had the geographical location, but can you use what it does? So gym or fitness?
Yeah, as long as what we you can, as long as what we say there's something distinct, a distinctive element with it. So it could be, EasyJet gym. EasyJet is the distinctive area, the gym is the descriptor. Gotcha. So yeah, as long as there is something carrying the generic term or the common term. Yes.
The key is it's distinguishable. That's probably the word.
Yeah, yeah. You've got to add something to it that makes it more distinctive for your organisation. Yes.
Yeah. Okay. Jonathan, you popped your hand up. You just put it down. Are you still there? Did you want to ask a question? No, Jonathan's gone shy. Deans, your hand's up.
Yes, hello.
Yeah. Hello, go for it.
Yes, hi Gary. Basically, I'm trying to design a musical instrument which is a digital instrument, and there are other patterns involved, basically. So the way it works, it's completely new. So the functions are new, but I'm combining products that are patented already. Can I still patent my product?
Yeah, absolutely. What we find these days is we don't get a brand new idea. What we'll get is an incremental change to an existing product. Yeah. So if you think in terms of, I mean, everyone's got a mobile phone these days. Go back maybe 10 years, there was no camera on it. So my idea would be to incorporate a camera into a mobile phone. So mobile phones have been around for 10, 20 years. But my idea of actually incorporating a camera would have been patentable simply because no one has done it before. So exactly the same for you. Although there's things out there already in the same sort of vein of what you're doing, providing yours is absolutely new, no one's done it before, then yes, you would file an improvement to a musical instrument, and you would get the patent for the improvement that you've made to that particular invention.
That's fantastic. Thank you very much, Gary.
Okay.
Thank you, Deans. Just a couple more minutes. So I've got one here from Judith, who says that she's creating some educational material to be used in schools, and is asking if she needs an ISBN. That's an international standard book number.
From our point of view, you don't need to, but when it comes to schools, I think they would you would need to have it, simply because it shows then you're reputable, you're reliable, it's something that you've got basically a qualification or a right to use. So from the copyright point of view, no, but yes, when it comes to selling, people will, certainly schools would probably like to see it, that you've got an ISBN number on your product, yes.
Yeah. Okay, and Andy, are you there at all? No. Okay, I think I've got his question here anyway. Are government agencies able to contractually permit to retain IP on contractors' work?
Yeah, most do.
Right.
You'll actually find in the small print of any contract that comes out from a government agency, there will be a clause that will say anything you do, create, make, will transfer, ownership will transfer to us. basically. I think it's common in practice in most organisations these days because, you want to own. You don't want people walking away with, but it's negotiable. If you have got something you really do want to own and not allow, the government to own or the person you're doing it for it to own, then have those talks beforehand, because on day one it's worth nothing, and it's negotiable. Once it's worth a few bob, then there will be problems with it.
Yeah.
So it's negotiable, and do it on day one, but there will be a clause in most contracts these days. So read the small print.
Okay, thank you, Gary. Just quickly going back to Judith, just come back in again and ask, where do you get an ISBN from?
Oh, right, that I don't know, actually. It's probably something on our website. I'll probably investigate that for you and come back to you afterwards.
Okay.
But I think I've got one in the past for something we produced.
Yeah.
So I probably have got some paperwork on it somewhere, so I can find out for you.
Okay. Right, brilliant. Well, we're bang on time as well, 12:30. So thank you very much, Gary. Much appreciated. If you want to see the handouts for this, it's available as a PDF, and you can just drag the PDF into your work area. So my thanks to Gary for your time this afternoon. Next month, we're going to be discussing something called B-Anglia. That's Business Energy Efficiency Anglia. So this is really aimed at businesses aimed in this part of the world, in Norfolk and Suffolk. It's free support in the form of energy audits and grant funding. So if you're a small business that's spending a lot of money on your energy bills, this will be the one for you. So the link is there if you want to register for that. So we hope to see you next time. But from myself and from Gary, thank you very much and goodbye.
Goodbye. Thank you.